And I've just put a simple agenda in the chat that everybody should be able to see. Okay, folks, if it's all right with you, I'd suggest we go ahead and begin.
Right. Good afternoon. I'm the Reverend Jane Borum, NOAA's Criminal Justice Task Force co-chair. NOAA stands for Nashville Organized for Action and Hope. The Criminal Justice Task Force mission is to organize and take actions for a more humane, safe, equitable, responsive, and restorative system of justice in Nashville. These activities occur through a lens of addressing systemic racism. On behalf of NOAA, we welcome our district attorney candidates and you, the voters. Today's forum is a webinar, so you will see only candidates and speakers. In Tennessee, district attorneys are elected by the citizens of their judicial districts to serve a term of 8 years. They're responsible for the prosecution of criminal cases on behalf of the state, but ultimately, their day-to-day responsibilities include much more. They advocate for victims to ensure their rights are protected and assist them in navigating the criminal justice process. They partner with treatment centers, nonprofits, and support services in an effort to prevent crime. They advocate and defend our most vulnerable populations. They also oversee the administrative needs of their offices to ensure their teams are equipped with training, support, and resources they need to promote public safety. Today, we will hear from 2 of the 3 candidates, Sara Beth Myers and Danielle Nellis, for the District Attorney Office. They are joined by current DA, General Glenn Funk. Questions have been prepared for all 3 candidates. The Reverend Davy Tucker of Beech Creek Missionary Baptist Church and faculty at American Baptist College will present the questions. Audience questions can be placed into the chat room, some of which will be presented by moderator Reverend Tucker. Our timekeeper for this afternoon is Erwin Vennick, member of NOAA's Criminal Justice Task Force. He will let our candidates know when their allotted 2 minutes for answering each question ends. He will verbally announce a 30-second warning and time's up end to the candidate's answer. So begin the questions. Reverend Tucker.
Thank you, Jane. Good afternoon, everyone. And again, we welcome you to this great panel discussion between the candidates running for the district attorney office here in Nashville. I want to begin by asking that each of you take no more than 2 minutes to introduce yourselves. I'm going to begin here with General Funk, and then after that, Ms. Myers, and bringing up the rear, Ms. Nellis.
Okay, great. Thank you, and thank you to NOAA for having this very important webinar. My name is Glenn Funk. My background is that when I got out of law school in 1985, my first job was as an assistant public defender working for AC Wharton in Memphis, Tennessee. After a few months there, I knew that I had wanted all along to get to Nashville, and District Attorney Tom Schreiber hired me to be an assistant district attorney. I prosecuted for 3.5 years. At the end of that time, I went into private practice and did primarily criminal defense for the next 25 years. In 2014, my predecessor, Tori Johnson, retired. I ran for this position and was elected. The reason I ran for this position is because my time as a public defender made me a better assistant DA. My time as an assistant DA made me a better lawyer in private practice. And over those 30 years, I saw a number of abuses by the criminal justice system on people in the community. A lot of times it was folks that were not the affluent folks in town. A lot of times the force of the criminal justice system would bear down on people who were the least able to defend themselves. And so on September 1st, 2014, the day that I took office, the criminal justice system in Nashville fundamentally changed. Prior to that, it was a system that was focused on retribution and incarceration. When I took office, I said, you know what, we need to be about first of all, deciding whether the criminal justice system needs to even get involved in the situation, whether it's a driver's license.
30
case,
seconds.
whether it's a mental health case, whether it's a situation where there might be substance abuse. Do we even need to get involved, or do we need to just dismiss that case ahead of time? And so what we were trying to do is try to balance this to where we would handle that. We would work on rehabilitation, we would work on deterrence where available, and only use the severe sanction of incarceration when it was absolutely necessary. So I've looked forward to, over the next hour or so, being able to talk about the accomplishments my office has had over the last 8 years.
Thank you.
That was very gentle, Erwin, when you called time on that. So
Ms. Myers?
Thank you so much. Thanks to Noah and everyone for hosting this. My name is Sara Beth Myers, and I'm running for district attorney here in Nashville. I've been a local, state, and federal prosecutor for the past 10 years, and for the past 5, I've been the civil rights coordinator and the human trafficking coordinator for 32 counties here in the Middle District of Tennessee. And as part of my platform, I have 3 different pillars: crime prevention, civil rights, and restorative justice. For the last 8 years, the crime rates have gone up substantially in Nashville. And that's not just because of a population increase and not just because of COVID, it's because of policy failures of the current administration. So to prevent the rising crime rates in Nashville, I'm going to divide the DA's office up into precincts and assign assistant district attorneys to neighborhoods to, instead of being reactive, being proactive, going out into the neighborhoods to build relationships with businesses, nonprofits, churches, mosques, neighborhood associations, to make sure that we are targeting resources to prevent kids from going into the system in the very first place. In addition to that, from a civil rights standpoint, I'm going to conduct the first civil rights criminal justice audit of Davidson County. From arrest to sentencing, we need to know exactly where the disparities are in our system before we can actually make real systemic reform. No more simple surface or simple changes. We need to know precisely where they are so we can address them.
30 seconds.
To train law enforcement on violence prevention and hate crime identification, which I've been doing for the past year with DOJ, and which will be mandatory. And finally, I'm going to create the office's first restorative justice unit in Nashville to help people transition from incarceration back into the community with resources they need, not just from probation, but from nonprofits, and building relationships with them. And for nonviolent offenses, helping people get the resources tailored to them that do not involve incarceration at all. So mental health treatment, drug addiction treatment, wraparound services, and I hope to earn your vote on May 3rd. Thank you.
Thank you, Ms. Myers. Ms. Nellis, please.
Good afternoon, everyone. I was making sure I was not on mute. Thank you to Noah and all of the partners for hosting this very necessary forum. My name is Danielle Nellis, and I'm running to be your next district attorney. If there's to be action, if there's to be hope, if there's to be systemic change, and if our city's criminal justice system is to accomplish those things set forth by Reverend Jane and as required of the district attorney's office that is not happening right now, then we must stop using the bodies of Black, brown, and poor people as the currency of criminal justice and public safety. I'm running because the body of my Venezuelan immigrant father-in-law was found dead in the passenger seat of his car in 2013. The body of my Black gay male cousin was found lifeless in his home in 2014. And over the course of 2017, moms, dads, community members across this city could no longer hug the young bodies of their precious teens whose lives were snatched from them. And several of those young people who lost their lives that year were my Sunday school children. Most of the kids that died in 2017 when we had that uptick in youth and juvenile violence were Black and brown children. I'm running because my grandfather, Reverend Dr. Inman Odie, was beaten by police and wrongfully arrested right here in this city. My father was harassed by officers as a youth, and my brothers, bearing the trauma that is fully understood by well over a third of our population, be it Black, brown, poor, immigrant, LGBT, or otherwise marginalized, they understood that instead of stopping in the middle of the night on one of the darkest parts of Clarksville Highway, they drove less than a mile to our driveway so that their attorney sister could bear witness should anything happen. Ladies and gentlemen, I am running today because my life experience requires it. but also because my over decade of professional experience has uniquely prepared me to do this work. I've been a defense attorney, a prosecutor, and clerk for a criminal court judge, and I'm the only candidate with a written policy platform outlining how I intend to move the city forward. So I would appreciate your vote on May 3rd.
Thank you. General Funk, what would be your priorities if you are elected to a second term as Metro District Attorney?
All right. Well, first of all, over the last 8 years, we've been able to have over a 95% conviction rate with regards to the violent crimes of murder, rape, armed robbery. We've also done wonderful work in the domestic violence arena by forming a team of 9 assistant DAs, 9 victim witness coordinators, 3 prosecution support unit investigators, and an administrative staff that have produced tremendous results. We've also, even probably most importantly, we've cut the incarceration rate by over 50%. Sheriff Hall has less than 50% of the total inmates in jail every night, which means over 1,600 people are at home tonight with their families and going to work in the morning. Priorities going forward, we're already working on a juvenile assessment center, which will reach out to folks that are charged with status offenses such as curfew violations and runaway in an attempt to try to have some wraparound services for the juvenile and their family. That's what we've been working on for the last year. Hopefully that'll be in place maybe by the end of 2022. We're also working on with Judge Blackburn and the other criminal justice stakeholders, the sheriff, in particular in the mayor's office, on trying to help folks that have cognitive delays, but whether it's someone who's born with cognitive delay or a situation where someone may have had a brain injury, folks that are incompetent, and what do we do to support those folks instead of just arresting them and releasing them back out on the streets? Let's provide the support so that not only are they better supported, but so that they don't continue to commit new offenses. Those are the 2 things that are right on the plate.
30 seconds.
How many seconds?
30
seconds. We are also working with a number of stakeholders as far as what do we do to provide the supports for folks that are homeless, trying to make sure that the folks that are living in the encampments can actually get the supports they need. Start with housing, but also the drug treatment, job skills, try to see if we can't reach out to those people to try to make sure they're safer in the Nashville city.
Thank you. Ms. Myers, will you address the question, what would be your priorities if you are elected district attorney?
Thank you, Reverend. Yes, my priorities, the top 2 would be public safety and equity. So from a public safety standpoint, we have a crisis here right now in Nashville and Davidson County. And that is that we have a proliferation not only of violent crime, but of every type of crime here in Nashville. And just last year, I think it's important to note not what the conviction rate is, but what the dismissal rate is of cases that are being dismissed according to MNPD data. 87% of domestic violence cases were dismissed by this district attorney's office last year. 78% of child abuse and neglect cases were dismissed last year. 48% of robbery and carjacking cases were dismissed, and 65% of gun cases were dismissed. Those are intentional violent crimes. Instead, this district attorney's office has chosen sometimes to pick cases that are merely headlines oriented. So meaning, for example, the recent conviction of the nurse in the Vought trial, that which is a civil medical malpractice case. Those decisions of what not to prosecute versus what to prosecute are some of the most essential ones that a district attorney makes. And that is, from a public safety standpoint, we need to be focusing on violent crime, specifically firearm-related violent crime. And while those cases here locally are being reduced from felonies to misdemeanors, they are being prosecuted on the federal side. So that is contributing to mass incarceration, not locally on the state side, but on the federal side. From an equity standpoint, we have to do the criminal justice civil rights audit, the first of its kind. We can no longer just talk or pay lip service to equity in our community. As a federal civil rights prosecutor, the majority of my cases involved people of color and victims who were incarcerated. This gives me a unique perspective on how we need not only to reform, but revolutionize what prosecution looks like. It looks like restorative justice. If we are going to address the issues in our community, sorry, was that 30 seconds?
Yes.
Thank you. Then we have to make sure that we are approaching it from a community standpoint, because prosecution doesn't happen in a vacuum. That means building relationships. Thank you.
Okay.
Okay. Ms. Nellis.
Yes, thank you so much, Reverend Tucker. So my policy platform is written and has been written for several months, and it's been wonderful to hear my opponents move their language and their processes and their programming to more closely align with that which I've already put forward. My policy platform is based on 4 principles. They are community engagement, transparency, restoration, and prevention. Restoration is expanding the options for accountability, holding people accountable, certainly, but expanding those options to do so, working to reduce the harm in our community, and focus on larger healing for both the victims, the defendants, and our community. We have to consider these things, systematizing these processes and focusing on both safety and justice as we do it. So I've talked a little bit about restoration. I also believe we have to expand the options for pretrial services so that we are decreasing our reliance on cash bail. And in doing so, and in partnering with our communities, we are able to, as people are coming into the criminal justice system, assess them effectively, address the root cause, and pair them with community-based resources so that they're either not stuck in custody unnecessarily, not put through a screening process that arbitrarily chooses who is eligible for pretrial release and who is not, and really addresses the root cause so that victims aren't continuing to be traumatized in our community as people are brought in and let back out. So families are not ripped apart as people are brought in and let back out, and so our community is made safer. Of course, in doing so, we are working on prevention. And as you've heard, there is a significant community focus. NOAA and other partners here are important stakeholders in reforming and reimagining our criminal justice system. So my primary goal within those first 90 days is to identify stakeholders, invite them to the table so we can start reimagining together.
Thank you. This question will begin with Ms. Myers. Evidence shows that people of color and people who are low income in our local jails are often persons who have not been found guilty of any crime but cannot make bail. Many have families and jobs and are often held for months only because they are poor. The only difference between these defendants and others charged with the same or similar crimes is their lack of financial resources. Do you think this is a problem in Davidson County? And if so, how would you address the problem? Ms. Myers, we're going to begin with you, and then we're going to go to Ms. Nellis.
Reverend Tucker, thank you for that question. This, from the very beginning of my campaign, has been an extremely major issue for me because we've never seen real bail reform here in Nashville. And what that looks like is making sure that we're not penalizing people for their poverty and that we're focusing on issues that have nothing to do with the color of their skin, with their religion, with their nationality, with their ability to pay, but merely on, are they a danger to the community and are they a flight risk? Currently under the Tennessee statute, those are the factors that those two issues address, danger and flight. And right now in the federal system, there is no cash bail here in the Middle District of Tennessee. It can absolutely be done. That needed to be implemented immediately in Nashville upon the current district attorney's taking of office, but it didn't happen. So we know what to expect for the next 8 years. We need real criminal justice reform change, and that means not punishing a person because they can't make bail, which disproportionately affects people of color and vulnerable communities. I've seen how it does and can work in the federal system. We need to change that right away. And that's not just the DA's office alone, but in cooperation with the courts and in cooperation with nonprofits that can help address those issues from an expertise standpoint. because we can actually prevent people from having to stay incarcerated while they await their trial through third-party custodians, through GPS monitoring, and a shift of
30 seconds.
people in jail who can't afford to make bail, who may have committed, by the way, a violent offense, but can still afford to make bail and present a danger to the community, to simply, is the person a danger? End of story. And if they are, then they can be held pre-trial and have a speedy trial and not wait years in jail. But if they are not a danger to the community, there's no reason whatsoever that they should be sitting there simply because they can't pay. So absolutely, that's been a cornerstone of my platform, and that will be a priority for my office on day one.
Thank you. Ms. Nellis, same question. Do I need to read it again for you?
Please, it was a little long, but I want to make sure I answer it.
Evidence shows that people of color and people who are low income in our local jails are often persons who have not been found guilty of any crime but cannot make bail. Many have families and jobs and are often held for months only because they are poor. The only difference between these defendants and others charged with the same or similar crimes is their lack of financial resources. Do you think this is a problem in Davidson County? And if so, how would you address the problem?
Yes, it is a problem in Davidson County. Indeed, what we know of the jail population here in Davidson County is that 60% of the jail population right now are Black or brown people. And so despite a decrease in the overall number, we know there's still a disparate impact on our most vulnerable communities. As I've stated, one of my primary focuses is on addressing our pretrial release program by putting in place an effective screening tool as people are coming in contact with the criminal justice system defendants, identifying the root cause of their problem and connecting them with community-based resources. There is space for that allowed in our statutory structure already. As you all know, bail is governed by 4011, 115, 116, 117, and 118. 115 states the preference for release on recognizance, where judges are unable to find that that person meets the criteria there, then the next option is certainly to put them on some community-based type of supervision that is often overlooked, and we skip to 118, where people begin to assess the danger to the community and whether bail will keep our community more safe. We must look beyond simply safety to the community. That is important. It is important to make sure that people return to court when they are supposed to return to court. But what we know is that the likelihood of somebody repeating an offense or participating in criminal behavior is not simply that they are on bail or off of bail. It is whether they are in conditions that make it likely for them to participate in criminal behavior, and identifying the root cause of what brought them there in the first place. We are able to address those conditions, connect them with the community-based resources, and decrease the likelihood that they will reoffend, increase the likelihood that they will appear in court, and decrease the number of victims overall, thus reducing the harm to community that criminal behavior causes and focusing on healing our community as a whole. And as indicated, we cannot simply mirror the federal system, because the federal system, though they do not have cash bail, certainly hold people pre-trial. And we know there's still a disproportionate representation of marginalized communities in that system. And so we want to make sure we're not replicating a system that is also not effective.
Thank you. General Funk, do I need to read it again for you?
I've got it. Thanks, Davey. Yes, I agree with Ms. Nellis that we do not need to replicate the federal system, because in the federal system, nobody gets bail. 95% of the people are held pre-trial before they've even had their charges proven against them. That's not a good system. But as our Constitution and our code says, we need to balance public safety with the right for folks to be free while their case is pending. I've been working on bail reform for 8 years. Nashville now has by far the best system with regards to bail in the state. And really, I think it's the model for the entire country. When it comes to misdemeanors and low-level felonies, right now, no one in Nashville has to post a cash bail. Nobody. There are only a couple of exceptions, so I can't say exactly nobody, right? But there's a couple of exceptions. Domestic violence, right, may have to post a cash bail. People who are been arrested for DUI third offense or higher, because that could be a public safety issue. And if you've been arrested twice in the same week. And then you're only held overnight until you can have a constitutional bail hearing with a judge present and with a defense attorney present to be heard within 24 hours. Now, we have a city of 750,000 people, right? On a given night, we have less than 40 people in jail on a misdemeanor or a D or an E felony. Everybody else has been released without having to post any cash amount. Those folks then have hearings the next day, even those folks that haven't been just immediately processed out within the first 2 hours. And so we did an audit in both November and December. And the number of people who are held pretrial on misdemeanors in Davidson County for more than 48 hours on a given night was 3. Just 3. Nowhere else in the state, nowhere else in the country is as efficient and effective at trying to make sure that we are not incarcerating people pretrial. We've had meaningful bail reform by cooperation between my office, the public defender's office, the sheriff's department, the mayor's office. So we've got a lot done.
Thank you. The purpose of restorative practices is to hold persons convicted of offenses accountable, to hold persons convicted of offenses accountable for their actions while attempting to repair the harm done. This is a multi-part answer. What is your definition of restorative practices? When should they be considered and utilized as an alternative to incarceration? And which restorative practices do you believe are the most impactful? I'm going to ask that Ms. Myers would start this question, please.
I'd like to start with an actual example of a case where I used restorative justice as a civil rights prosecutor. So just a few years ago, down in Murfreesboro, 2 young men vandalized a mosque. They spray painted it with hate speech all over it, denigrating Allah. They hung bacon at every entrance, and they terrorized a congregation of people. Not just the congregation, but they harmed the community itself. It was difficult to build the mosque in the first place, and that community had not felt welcome from the very beginning. So it was a very difficult time. But after identifying those 2 men in conversation with the mosque leaders and the community and the defense attorneys, we came to a solution. They would not be charged with felonies. They were charged with hate crime misdemeanors. They did not serve any time in jail, but they attended a service. They publicly apologized. They learned about the Muslim faith. And then the leaders of the mosque came to the sentencing of those 2 young men, and they spoke on their behalf. And when they did that and said, any employer who calls to ask about these misdemeanor convictions on these young men's records can talk to us directly. The community was involved in that. The whole victim community of that congregation, the defense attorneys, the defendants, and everyone came to the table to find a solution in that case that was tailored to those 2 people and those actions. That is what I see as restorative justice. It has to bring everyone to the table because prosecution does not happen in a vacuum. It's not just one person in one case. It affects an entire family, a community, the defendant, and victims themselves. And all of those must be considered. And so those resources must be tailored to do that in order to prevent additional harm in the future. So it's tailored to prevent the same thing from happening again in the most efficient way possible, in the most healing way possible.
Thank you, Ms. Myers. Jim Funk.
Sure. Restorative justice has a definition as a program. And in restorative justice, what happens is that the person who caused the harm has to repair the harm to the person who was harmed, has to repair the harm to the community, has to repair the harm to their own family, and repair the harm to themselves. Judge Calloway, our juvenile court, plus me and Stacy Miller from our office, plus public defender Dawn Diener and chief of staff for Judge Calloway, Kathy Sinback, as well as a member of the police department, traveled to Oakland to study the program that Oakland already had in place, that had been put in place by a nonprofit called Impact Justice. We did that in 2016. And what we found there was a practice in where a community-based organization worked with the court system to divert folks out of the system to where they wouldn't even be charged, much less convicted or incarcerated. The Oakland DA's office had been doing this for over 12 years at that point, and they had less than a 12% recidivism rate out of their juvenile offenders. We went across the bay to San Francisco, where they had a pilot program for 2 years, and they were still operating at a 0% recidivism rate. We came back here and we started working on putting this in place. Now you have to have a victim component to that. And so Tennessee Voices for Victims, an outstanding victim rights organization, agreed to work with the juvenile court to make sure that victims were supported, and it was a want to, not a have to. Nobody was going to force a victim into entering into this program. And then Judge Calloway found the Rafa Institute that's run by Travis Claybrooks to actually do the type of work to make sure that this repair was done in a way that ended up validating both the person who was harmed and the person who caused the harm. Because ultimately they have to get together for a meeting at the end of this where the victim can ask the hard questions. Why'd you pick my house? How long had you been casing my house? Did you realize when you stole my car that I was going to miss work and my family might go homeless? Right? Those types of questions, because they need to have that closure. 30 seconds? Okay. They need to have that closure. We've now had a restorative justice program in our juvenile court for coming up on 4 years in June. We've had over 65 youth go through the program. I am proud to report that only 2 of those 65 have committed a new offense during those 4 years. A 3% conviction rate. I mean, a 3% recidivism rate. That's amazing. And now we're working with the general sessions courts to try to expand that to the adult courts.
Thank you. Ms. Nellis.
Thank you
Do
so
I
much.
need to give you the 3 subparts to that question, or do you have it?
I'm going to think that I have it. And if I don't,
Okay.
then please, by all means, Reverend Tucker, correct me. So restorative practices, first and foremost, I want to, as the ethos and the filter through which we run every case, ask the questions: what is accountability, what's harm reduction, and what is healing? Because that is restoration. And those are restorative justice principles that we have to ask. And it shouldn't be simply programmatic and those that qualify for programs, but every assistant DA must be trained to ask those questions. In order to expand the options for accountability as people come through the criminal justice system, we must partner with community stakeholders to find out other options for holding folks accountable. And the way that I would like to do that in the adult space is through the establishment of a neighborhood courts program. We see that in other jurisdictions, and I can give you examples of that if you'd like to talk about it offline. But what it does is it asks those questions. It brings defendants to the table and victims to the table, and allows for accountability truly to happen. Accountability is saying that, yes, I did it. Yes, it was wrong. No, I will not do it anymore. And I will take steps to make sure that I don't do it anymore. And that I answer the questions that the victim may have. And the victim is able to, the harm caused to the victim is able to be reduced, and it functions to heal our community. Our neighborhood courts model would be ideal here in Nashville because we have such a unique and beautiful ecosystem of nonprofits and community organizations, stakeholders that are truly involved and truly value uplifting our community. So why not pull those stakeholders to the table instead of having criminal justice live in a silo? And most importantly, what that allows us to do is to humanize individuals. In our current process, yes, there are diversionary programs for our juveniles. Yes, there might be a pilot or small program, but it cannot simply be about programmatic restoration. It must really be the ethos of the office so that we are reducing harm overall, we are fostering healing, but we also have programs to do that in addition when we can divert people away from the court system as a whole.
Thank you. Thank you. I'm going to read a question from the chat. As a defendant and observer at many court hearings, largely in civil liberty cases, I have observed that prosecutors in trials are usually focused on conviction, privileging the testimony of arresting officers, and seeking jail time upon conviction. Will you try to create a culture of prosecutors focusing only on justice for defendants and victims rather than conviction and penalties? Ms. Nellis, I'm gonna let you start that one.
Yeah, I think that taps right into my last answer. You know, the ethos, the filter through which we must run every case is restoration, asking those 3 questions. And in doing so, we're able to humanize the individuals as they come through the criminal justice system. And I think we really have to focus on humanizing each and every stakeholder. Unfortunately, the system is set up to dehumanize people. When I was a defense attorney, you know, my clients, young, 18, 19, primarily indigent, because most of my clients were only paying a little bit, or I was taking them via appointment. And they really needed more than what the system was providing or what the prosecutors were offering. Thankfully, because I'm from Nashville and I'm very connected with our community here, my family's been here for over 6 generations and I've lived in the nonprofit space, I was able to access resources and put them in contact with people in the city and programs in the city where they were able to address whatever the underlying need is. But we have got to figure out how to create more space so that people can be humanized. So victim stories can truly be told and heard. So defendant stories can be truly told and they can be heard. Because quite frankly, the way we do it right now is by huge cattle calls. You have a 9 o'clock docket with 100 people on there. How can we expect an ADA to truly see and value the people who are on their dockets as well as the victims, no matter how many victim witness coordinators you have working on case or cases, and see it just because of the volume of cases? So if we're able to decrease our caseloads overall, if we're able to increase or figure out ways to create more space to hear from each other, if we're able to train, my background is in education and policy. You said 30 seconds, Arvin?
30 seconds, yeah.
Okay. My background is in education, diversity, equity, and inclusion training in education is what I thought I was going to grow up and be a teacher. So certainly I have the background to implement the training processes necessary. There are over 70 assistant DAs there in the office, 100 and something staff people, and it's got to be a complete training process, not because we are belittling people, but because we are uplifting people in the office, identifying their best skill set and getting on the same page with a clear set of principles and processes about how we move our criminal justice system and our city forward.
Thank you. Ms. Meyer, do I need to read that question again to you, or do you have it?
I think I have it, Reverend Tucker, but thank you.
Okay.
So in terms of a culture of prosecutors focusing on only justice for defendants and victims rather than conviction and penalties, I think that there's something key in terms of a shift in mentality that needs to happen, and something that as a domestic violence prosecutor specifically, I learned very early on too. Sometimes you're not going to have the evidence to go forward with the charge, even if you know that a very serious, sometimes violent crime was committed. Sometimes you do have the evidence, but you can't bring the charge for whatever reason. It may actually affect the safety of the victim in that case. Prosecution does not happen in a vacuum, as I said earlier. It has to be the community that is taken into account, and that person's community as well. And if a prosecutor is just focused on winning and getting stats like a conviction rate, then that is not the place that we need to be as a society. We need to be looking at how many people are not going into the system because of positive preventative measures that we are taking deliberately. We need to look at how many people have committed offenses, but then don't reoffend again. That is a measure, or should be a measure, of our success. And it is so important for a prosecutor not only to make those decisions that are important about charging behavior, but it is just as important, if not more important, the cases that a prosecutor decides not to pursue and not to charge.
30
and
seconds.
That is why prosecutorial discretion is so key. And that is why we desperately need a restorative justice unit in the DA's office who doesn't approach things from a zero-sum traditional approach, a win versus a loss. It is a win for the community if we prevent someone who has committed a violent offense from committing another one. It is a win for the victim and the family also to know that that is not going to happen to someone else, and to have that restorative procedure in place that is tailored to the individual.
Thank you. General Funk?
Well, first thing we need is what I thought was diversity in the office, to bring a variety of viewpoints into the office. When I inherited the office, it had 3% Black ADAs, 0 Hispanic. We're now 28% diverse with regards to our assistant district attorneys. Not only are we 28% throughout the office, it's 33% of leadership within the office. people who are in the rooms when policy decisions are made. Not only that, 70% of the ADAs have criminal defense backgrounds as part of their practice, which lets them know what it's like to sit in a room with a person who's been charged with a crime and who needs to get out of jail so that they can get back to work and make sure that their family is supported. It's that type of background that changes the attitude of prosecutors. Now, what have I done during my 8 years? Well, I have partnered with a number of judges and other criminal justice stakeholders to try to get to these interventions, right? The CARES Court is really important. And I partnered with Judge Bell as she created the CARES Court, which operates out of the Magruder Center in the 37208 and takes people who are charged with felonies and reduces that to misdemeanors to where there won't be convicted felons and won't be going to prison. I've partnered with Judge Calloway, as we've already discussed, on restorative justice. The Behavioral Care Center I created with Sheriff Hall, and divert cases out where it's a mental health issue that can be addressed by this very real hospital that he has put together and support the folks with mental health issues. It's been open for 18 months now. For that population, 5% recidivism.
30 seconds.
For the folks that have been diverted out of the criminal justice system and been treated with the behavioral care center. And those stays are between usually an average of about 8 days where they get a new diagnosis and stable on their meds and find housing. The mental health court with Judge Melissa Blackburn sees less than a 15% recidivism rate because she's able to work with my office and with the public defenders to give the folks the support that they need.
Time.
That was time.
Time.
Ran out quick. I was only halfway done, but we'll go get back.
Thank you. This is a question we'll begin with Ms. Myers, and this is one of the moderator's questions. Brian Stevenson said it is better to be rich and guilty in the US versus poor and innocent. Whether it's government, NGO, or the academy, research has shown that the disparities that exist in the application of punishment is much more severe for Black, brown, and poor bodies. Often when asked, DAs will exert that each case stands alone. If that being so, number one, why do these disparities still exist? And in a concrete way, can you share what you will do in an attempt to address these disparities? Ms. Meyer.
Thank you, Reverend. I wish I had more than 2 minutes, but so disparities obviously still exist in the system, and merely hiring a diverse workforce is not enough. It is a great first step, but in terms, if that would have worked to solve the disparity issue here in Nashville in our district attorney's office and in the criminal justice system, we would have seen a reduction of disparities already in the past 8 years. And we haven't, because that's not a systems change. That's merely a first step. And so what we need to do is actually figure out what's going on here in Davidson County. We have to lift up that rock and take a hard look from a civil rights perspective in the system as a whole. Not just one case at a time. That's easy to say. I'm not talking about doing what's easy. I'm talking about what's doing hard and what's hard and challenging the system itself. One case at a time won't cut it, but if you analyze the system as a whole, those cases stack up and you begin to see patterns based on race, gender, nationality, sexual orientation, and religion. And I guarantee that when we do that audit, we are going to see patterns. It's easy for someone to say, I'm not racist. I don't know how many times I've heard that in my civil rights cases and investigations. But when you look at their actions and what actually is occurring on a systems level, they may be sentenced differently, people who look a certain way versus people who look another. People who are pulled over and given a citation in one part of town versus people who are incarcerated in another part of town, served with a warrant. Those are the disparities that we need to be identifying in the system.
Could I just force you on the last portion of your question? What would you do?
What would I do? So I want to conduct that audit to see first, where the disparities are so that we can make the changes. And if there are issues in a certain part of town where people are being treated differently or people are being sentenced differently in this particular area, then we can actually address the core issue of the problem. If it's a person, if it's a system, if it's a law that needs to be changed, then we change the law. I've done that 9 times through the nonprofit that I founded. So many of the disparities that we have originate in antiquated laws that we have, and a DA should be a policymaker to resolve those issues as well.
Thank you. Jim Funk.
Well, sure. You know, through not only the efforts that we have done to try to have diversion through all these programs, you know, the number of other programs, the Hearts Court helps folks that are human trafficking victims. We dismiss all revoked driver's license cases and help people get their driver's license. That helps end that disparity with regards to poverty and race, because now 0, whether you're Black or white or Hispanic, get convicted of driving on a revoked license. The recovery court run by Judge Robinson, the drug court by Judge Smith, Judge Dalton. We also have an assistant DA going through outstanding warrants for failure to appear in court or unserved warrants and dismissing those minor charges that can be dismissed if we weren't going to be interested in prosecuting them anyway. You know, that eliminates the disparity. We have been working very hard to make sure that all of the incarceration rate has come down from 3,100 a night to 1,500 a night. The people that participate in these programs and have their cases dismissed or diverted, the people who, because of bail reform, are no longer in jail. When nobody's in jail for misdemeanors on pretrial and everyone's on pretrial release, there's no disparity there. Those are real programs that have seen real results. I could not be prouder of the fact that we have eliminated those disparities, and we're continuing to work on them going forward. You know, simple possession of marijuana had a huge disparity on like 70% of those were against Black folks or Hispanic folks. All right, even though that's an issue across the entire spectrum. All right. It does nothing to promote public safety, very little to promote public health. We eliminated the disparity by me just saying we're no longer going to prosecute those cases. All those cases are now dismissed before the person's even booked and processed. So we're working hard. We've made a lot of progress. Do we have more to go? Sure we do, but we're making tremendous progress.
Thank you. Ms. Nellis.
Could you please repeat that question, Reverend Tucker? I'm not sure that I was, I heard it, but it seems that the answers may not have exactly matched.
Brian Stevenson said it is better to be rich and guilty in the US versus being poor and innocent. Whether it's a government, NGO, or the academy, all the research has shown the disparities that exist in the application of punishment in the US on Black, brown, and poor bodies. Often when asked, the response from DAs is something similar to each case stands alone. But if this is true, the outcome remains the same. The disparities still exist. How would you address these disparities?
Thank you. Yes, I agree with Mr. Stevenson's very clear assessment of our criminal justice system in its current state, both nationally and locally. We know that Tennessee incarcerates at a higher rate than any other Western nation per 100,000. We have the highest rate of incarceration, and the vast majority of those bodies that are in custody are Black, brown, and poor. What we know to this date is that 60% of the bodies in our jails right now are Black and brown people, and that's after 8 years of whatever efforts have been put in place. So to address these issues, I do believe we have to be data focused, as was written in my policy platform. We have to work with MNPD, Department of Criminal Justice Planning, the criminal court clerk, to identify where the crime is occurring. Sure, all those things. We have that data. We just need to make sure that we are getting it all in one place. We are synthesizing it, and then we are using it for training and the implementation of programs going forward. One of my first hires, I hope to be my first hires, this is one of the only things in my policy platform that requires probably an investment or a shifting of people in the office, is to hire a criminologist. a statistician who focuses on crime, because once we get this massive data into one place, because we have it all, we have it in our CJIS system, the criminal court clerk has access to it. Phil Williams and his whole crew have asked for it before, but it simply hasn't been released or synthesized. Once we get that, we need somebody to synthesize it, help us understand what it is telling us. Tell us by judge, tell us by ADA where the disparities exist, and then look inside. We cannot point outside into the community and what the community is or is not doing until we look inside as a DA's office and say, in this office, here is where the problems exist. Here is how we address them. We work to systematize a lot of the processes, including, automated expungements. Things like that address disparities, right? Understanding, training like that, training based on the data. Yes, and again, a lot of this is in my policy book, so I would highly encourage you all to go to nellis4nashville.com/issues that addresses many of these disparities.
Thank you. The practice of over-indicting or charging defendants with crimes more serious than the evidence supports is perceived to be a common practice in Davidson County. Do you agree with this assessment? One, and if elected, what steps, if any, would you take to curb this practice? I want to begin with General Funk, and you'll need to adjust your answer.
Adjust my answer? I'm sorry.
Well, the end of the question is, if you are elected, what would you do?
Okay.
So I'm going to read it over again for you. The practice of over-indicting or charging defendants with crimes more serious than the evidence supports is perceived to be a common practice in Davidson County. Do you agree with this assessment? And then, if elected, what steps, if any, would you take to curb this practice?
First of all, the perception would have been correct prior to 2014 when I took office. Right? In fact, prior to 2014, this office would sometimes file a notice of death, of seeking the death penalty, and then be willing to use that as a bargaining chip to try to get someone to plead guilty to life without parole. We don't overcharge. Now, at the general sessions level, we don't make the charge. The police officer makes the charge, and the commissioner then signs it. We don't participate in the charging at the general sessions level. The question talked about indictment, though, and we do present cases to the grand jury and present an indictment that the grand jury has to determine whether or not to indict for that level offense or for a lesser offense. I tell the DAs we have two hurdles to clear. Number one, do not charge an offense unless you believe beyond a reasonable doubt that the person is guilty of the offense for which you have charged them. Secondly, you cannot go forward unless, with the proof that will be available to this jury, a rational jury can convict. We don't have to be the overwhelming favorite on it, but we have to believe it, and we have to believe a rational jury can convict based upon this proof, right? We can sometimes be the underdog, but as long as we have cleared those two, if we cannot clear those, even if we believe it beyond a reasonable doubt, but we don't have the proof, or if we have a proof that we could then argue, but we don't believe it ourselves, you can't go forward on that offense. You can't charge it. You can't go forward on the charge. Your job as an assistant DA is to reduce it to a offense that can be clear, can clear those two hurdles, or even dismiss the case if we don't have a case. That's how we charge, and that's how we go forward.
Thank you. Ms. Nellis.
Yes, I don't think we can pass it off on the grand jury as the people who indict. We cannot pass it off on the officers as the people who charge or the magistrates who accept, because we know that once cases hit our dockets, we have all the power in the world to change the charges that we're pursuing in our negotiations. We can orally amend warrants in court, in general sessions. It is done all the time, unfortunately, not with any consistency, and only mainly done for bargaining purposes. And so I would absolutely discourage practices that would allow for the continued overcharging and over-indictment of cases. I've seen it firsthand where it has happened. And despite what is being said here, I cannot say that cases that are coming out of the grand jury are not consistently settled for less than what they are charged, because the facts only support that. So certainly I support practices that would prevent overcharging, and more than that, I would support the disclosure of evidence early and often to the as far as it will allow for victims to continue to be safe, because it is very difficult to argue cases and advocate on behalf of defendants when you're doing it only based on the warrants that are there and the information you've gathered from your client. This is what is fair to the defendant. It is also what is fair to the victim. We set victims up for disappointment when we overcharge cases, when we walk in and we expect for them to be charged as first-degree murders, and they are negotiated down to some type of voluntary manslaughter or were promised jury trials, when indeed they are settled behind closed doors. And so I would certainly adopt practices and put in place practices to charge appropriately early, to amend early, and to hold accountable early. I also, as stated, would work hard to divert cases out of our criminal justice system, particularly those that are low level and non-victim related, into a neighborhood courts model that I would love to implement and make sure that people's underlying issues are addressed so that we're not seeing them come in and out of the system, and that as they are in the system, there is truly a fair access to information.
Thank you. Ms. Myers.
Thank you, Reverend Tucker. I think there absolutely is a practice of over-indicting here in Davidson County. And as I said earlier, it's just as important for a district attorney what cases not to prosecute as what cases to prosecute. And I think a great recent example of a decision that was made to prosecute with the full power, of the law was the Redonda Vaught case. That verdict just came down last week. And the decision to pursue criminal charges, which could have amounted simply to civil medical malpractice, is an absolute misuse of resources for the district attorney's office. That's just one example of many for the power of a district attorney in using that prosecutorial discretion to overcharge with just looking at one case and one person versus looking at the community and the system that it affects and how it affects every single person in our city and really in our country. Those decisions carry so much weight. And instead of looking at what could I charge this person with, what should I charge this person with, or should I charge this person, full stop. That needs to be a big pause for any prosecutor. Should this person continue to be charged with this crime? And certainly if there's not evidence for it, you don't pursue it, period, full stop. But a decision not to prosecute, right? So going back to the Moss case,
30 seconds.
Did I have charged a felony in that case? Yes. Was there evidence to charge a felony? Yes. Did I? No. Why? Because it was a restorative justice approach to get everyone, including the community, at that table to figure out what would be a healing process and what would be tailored to those two people who committed the offense and to the entire congregation as victims and to the city of Murfreesboro itself, because of that relationship and that tension that they had existing in the first place. So whether or not to charge a case and whether or not to indict in the first place is one of those most crucial roles that a district attorney has. I'm sorry, did you say that was time?
Time.
Yeah.
Yes.
Oh, sorry. Sorry. Thank
Okay,
you.
now this is just a yes or a no that will possibly allow us to get another question in. Electing someone as district attorney for a term of 8 years is a very generous public commitment and show of confidence. A term we believe is too long without periodic public engagement. Will you agree to participate in an annual forum with NOAA and its partners to review issues related to criminal justice and discuss the progress you are making to address your campaign concerns and promises? Ms. Nellis.
I will do you one better than that. As stated, I will have quarterly meetings at least with stakeholders, inviting you in so that you can understand what policy changes have been made, ask questions about them, and be fully up to date. I invite NOAA and all of our other stakeholders.
So your answer is yes?
Yes, kind of,
Okay.
yes.
Ms. Meyer,
Absolutely.
General Funk?
Yes.
All right, thank you much. Erwin, was that time?
You can go on to another question, but not any other question.
Oh, okay, okay, all right. Next question, and we're going to begin this question with Ms. Meyer. It has been previously reported that zip code 37208 has the highest rate of incarceration in the United States. Nonviolent offenders have been sentenced to spend decades in prison. Collateral damage to families, children, and communities has been profound. Yet some in the public clamor for a tough on crime approach. Do you think this high rate of incarceration is an issue? As district attorney, what can you do about it? And are you afraid of being accused of soft on crime? Please, the three subparts of that is, do you think this high rate of incarceration is an issue? As district attorney general, what can you do about it? And are you afraid of being accused of being soft on crime? We're going to begin this question with Ms. Myers, and I'm asking that you would particularly address those three sub-questions.
All right, thank you, Reverend Tucker. So is there a disproportionately high rate of incarceration in 37208? Absolutely. As it affects people of color, that is a statistical fact. And I can say personally too, as a civil rights prosecutor where my victims were inmates, I have predominantly seen how that plays out in the jails themselves across the 32 counties in the Middle District that I worked excessive force cases in. So to fix that, that is predominantly what I'm looking at in my platform. That's how the platform of crime prevention, civil rights, and restorative justice all work together. So from that crime prevention standpoint, dividing the office up into those precincts to make sure that we are assigning those ADAs to neighborhoods to identify the issues, the reasons why crime is happening in those areas is how we can address kids from going into the system in the first place. So that's what I want to focus on. It's going to look a little bit different in every single neighborhood in Nashville because it should be tailored to that community. Some people may want to focus on a community center and having more activities there for kids to prevent them from going into crime, from having it open later. Then we may need legislative solutions to address the guns and cars issues that we're having across this city to prevent car break-ins and getting guns and going and escalating to violent crime. That may be a legislative solution that the DA needs to pursue. But we may see patterns once we actually get out into the community in a very strategic assigned way in order to tailor those resources once we identify the specific problems.
30 seconds.
Maybe someone wants more surveillance in one neighborhood, but someone wants less surveillance in another area for a variety of reasons. So that is something that we can absolutely work on proactively. And then am I afraid of being accused of being soft on crime? No, I'm not afraid of being accused of anything. All people need to do is look at my track record of results. I don't just talk about progress, I achieve it. I don't talk, I walk. And I want to make sure that that's very clear. And people can go to my website, myersforda.com, and they can see what I've accomplished for people.
General Funk, same question to you. Do you think this high rate of incarceration is an issue? As District Attorney General, what can you do about it? And are you afraid of being accused of soft on crime?
Sure, I think it's an issue. And yes, I've already been accused of being soft on crime. When I closed the 20th Judicial Drug Task Force, which was policing for profit and prosecuting for profit. It was a police department working where the district attorney was the head of it. It was a miniature police department that caused all kinds of conflicts of interest. And I shut it down and put the policing aspect back under the police department. 37208, let me tell you what I did about it. When I was a criminal defense attorney, I saw that first Chief Surpass and then Chief Anderson had instructed his officers to arrest every person for drugs and charge them with possession for resale. And then because almost the entire city is a school zone or within 1,000 feet of a daycare, everybody was charged with drug-free school zone violations. So somebody that might have a couple grams of cocaine for their own personal use would be charged with possession for resale in a drug-free school zone. Instead of looking at up to 11 months and 29 days on a misdemeanor, they'd be looking at 15 to 25 at 100%. And then you would get to court and your client would be saying, listen, it was for my own personal use. Yeah, well, do you feel lucky? Because what this prosecutor's offering you is a 10-year sentence where you only have to do 1 year and then you can be on community corrections. Either take the year and become a convicted felon for the rest of your life, or go to trial. And if you lose, you're in jail, you're in the penitentiary for decades. They railroaded thousands of people into jail, a lot of them for nonviolent, a lot of them out of 37208. I ended that practice on day one. We stopped indicting for that. And when we took the school zone enhancement off of every case that was pending.
30 seconds.
So, I've already done that. Now, there are still a number of folks in the penitentiary on drug-free school zone violations, right? None of them from Davidson County were selling drugs to kids through the schoolyard fence. None of them. And yet we did that because this office was about incarceration and retribution. And we've stopped that attitude. That's a real result that we have done. And I expect that we're going to be, that those statistics out of 37208 will change over the next generation as my policies come into effect.
Ms. Nellis, do you think this high rate of incarceration is an issue? As district attorney, what can you do about it? And are you afraid of being accused of soft on crime?
Yes, it is an issue. I grew up between 37208 and 37218, so I know it very firsthand and very personally. I also know that if the incarceration rate is high there, and assuming that crime happens in the area, we also have a slew of victims there whose lives have been upended by the crimes that are happening. What I will say to you is, and as far as being accused of being soft on crime, I hear that I'm being accused of that by my opponents as well. So it wouldn't be any new news, but no, I'm not concerned about that. What can I do about it? First and foremost, we have to understand why crime happens. The numbers of incarcerate, the rate of incarceration is consistent up to 2021, is my understanding, at least 2020. So that means under this current administration, the necessary changes have not been made and we have not addressed the root causes. We know that crime happens primarily as a trauma response, and crime is a resource problem. So we've got to identify the resources to address the underlying needs and the underlying trauma that has caused people to participate in whatever the criminal behavior is, assuming that crime has happened. If we are to address the policing issue, we must invite them to the table as well and discuss any over-policing issues that are happening in the area. But again, I also want to keep in mind that there are victims in 37208 as well. 37208 is where my cousin was murdered. And so we have to make sure that we're bringing to the table all of the stakeholders, including those who are justice impacted, whose votes may not get one of us into office, but whose lives are impacted by the decisions of the office.
30
we
seconds.
must invite voices of moral authority who are in that 37208 area doing the work already. We need not recreate the wheel, but we must invite them in. And we must do this through a design thinking process, which brings all of the stakeholders to the table, hears the ideas, aligns the resources, identifies the problem, expands the options for accountability so that we are fostering harm reduction and healing. We must align with our neighbors and our neighborhoods, not police precincts, and stand independent as representatives of the state of Tennessee as the district attorney's office. And we must systematize two-way lines of communication so that it's not just about personal contact with whoever's in charge.
Thank you. Mm-hmm. Please close your time with us today by clearly telling us why we should support you rather than your opponents. What will you bring to the DA's office that your opponents will not? We will begin with Ms. Myers.
Thank you, Reverend Tucker. So I am focusing uniquely on a crime prevention platform on civil rights and achieving better equity in Nashville and our criminal justice system. And finally, in restorative justice. We are well behind the times. And when you have heard the current district attorney say he's proud of his accomplishments, nothing's going to change in 8 more years. It's going to stay on track the way that it is. So I am not content with that. We are at a critical moment in Nashville as our population continues to grow, as our businesses grow, as more people move here. We need to make sure that we are addressing the key issue that is facing all of us here. And it's two-pronged. It's public safety and it's equity. And that means we have to change the way that we see and we operate in the criminal justice system. And that means that we have to be proactive out in the community in an unprecedented way. We can't just say, you know, it's simple to say, I'm not going to prosecute driver's license cases, which I'm not. I'm not going to prosecute marijuana cases either. That's a national trend as well. That's happening everywhere. It's hard to make the systems changes that are needed. But if you want real criminal justice reform and not just a tip of the hat or rhetoric surrounding criminal justice reform, but you want results, that is me. And I hope to earn your vote, because criminal justice will look much different under my leadership in focusing on crime prevention, civil rights, and restorative justice. I'm the only one who has local, state, and federal experience, who's drafted
30 seconds.
legislation, and who can get results for Nashville and save lives. Thank you. Hope to earn your vote.
Ms. Nellis?
Again, thank you to NOAA, the NAACP, and all the community partners, and thank you to each of you that attendees here. We have over 100 folks for those who are watching on Facebook. Criminal justice reform and public safety are my goals, and they are necessary to build a safer and stronger Nashville. I know that with all of my being that we can reimagine, and my candidacy is an invitation to reimagine our criminal justice system together. Quite frankly, we know that what has happened in the past 8 years is not working. We see that because, again, there are over 60% of the people, or about 60% of the bodies that are still held in custody are Black or brown. We know that the communities who have historically been negatively impacted by our criminal justice system are continuing to feel that impact. We also know that in the federal system that is attempting to be replicated by one of my opponents, we still have a conviction rate greater than 80% in sentencing, where even where there's an option for release, it is more likely that person will be pled out or receive a sentence to sit in jail based on the recommendation of the prosecutors. We know these things for a fact, and we know that the status quo, it will not work. But you have a choice and you can make a change. And I know I'm uniquely positioned to do it, not just based on my professional experience as a defense attorney, a prosecutor, and having clerked for a criminal court judge, as an educator, having focused on diversity, equity, and inclusion work, and holistically or inviting people in. But I know this because I carry our personal stories to the table, and that when it gets hard, when the system continues towards as the system continues towards injustice as it has historically, we have to have somebody that can put their stake in the ground and firmly move us forward. We can do this together. We can reimagine together. We can be principled together. We can do better together, and no one of us can do it alone. So I invite you to choose me, so that we can do better here in Nashville, so that we can build a safer and stronger Nashville together, so that we can have the criminal justice system that is befitting of our growing city. Choose P. Danielle Nellis for District Attorney on May 3rd.
Joe Funk?
Thank you. Justice is not a choice between public safety and fairness. Justice is boldly demanding both. My background gave me the wisdom to know the difference between a bad person and a good kid in trouble. And after 8 years, I have a record of accomplishments and promises kept. I said that I was going to diversify the office, and I have. I said that I would diversify leadership in the office, and I have. I made a commitment to public safety, and we've got the record to prove it through success in court. I said that I would reduce the incarceration rate, and I have. Those are real numbers. 3,100 people in jail every single night in Nashville in 2013, 1,510 every night in 2021. That's a real difference. That's because we've been working on programs like bail reform, where misdemeanors are no longer incarcerated. That's a position. That's a result of prosecutors not taking the position that people should be held in custody pretrial so that they could somehow extort a guilty plea out of them. We don't do that anymore. And people are only incarcerated pretrial if they're a real threat to the community. But not just bail reform. We've had over a dozen collaborations. None of those are easy, but collaborations with other stakeholders, whether it's the judges, whether it's the mayor, whether it's the sheriff. We've been working hard to have cross community solutions that have had real impacts on public safety, public health, and public health, right? What am I going to be doing over the next eight years? Finding more programs, because we're not done yet. I'm not done yet. Nashville needs to continue to grow and be an even better city 8 years from now than it is today. I've made progress over the last 8 years, and I hope to continue that progress going forward. Thank you.
Thank you. I want to thank each of our DA candidates for their participation today and wish you all well. I'll turn it over now to Reverend Borum.
Thank you. We also want to thank our candidates for district attorney, our moderator, and the voters, you in the audience, for joining this afternoon's informative event. NOAA's next candidate event is next Sunday, April 3rd, also at 3 p.m. This will include candidates for criminal court divisions 3 and 5. So please refer to the NOAA original flyer that has all the candidates and judicial districts for specific names of incumbent judges and their opponents. You can find that flyer on NOAA's website and or our Facebook page. Today's forum has been recorded, so you can also find that on NOAA's Facebook page. Davidson County's primary election is Tuesday, May 3rd. The general election is Thursday, August 4. We also want to thank NOAA's partners who helped sponsor this event: Nashville Community Bail Fund, Unheard Voices, Urban League, Temple Social Justice Committee, NAACP Legal Redress Committee, Choosing Justice Initiative, National Jewish Social Justice Roundtable, A Voice, West Nashville Clergy Coalition, the Jewish Federation, West End Synagogue Social Action Committee, Community Relations Committee of the Jewish Federation. Now hear what a former U.S. Congressman John Lewis, who struggled his entire life for all of us to vote, once said: "The vote is precious. It is the most powerful, nonviolent tool we have in a democratic society, and we must use it." Thank you all for attending today's event. Have a safe and peaceful evening. Goodbye.